In order to get CLE credits, you have to listen for the secret word. It will be repeated twice during the video presentation. And sometime during the original presentation, Karen CORSI gave a secret code, and she announced it and may have even held up a sign. And you need that code as well. So there's two codes: the secret word, which is audio only, repeated twice, and the one where Karen CORSI said it on the day of the presentation. Jot them down as you listen. You obviously have to pay attention. Good luck. I'm the de facto, I guess, education coordinator for the Passaic County Bar Association trustees. And one of the difficulties is, getting people to present, because everybody's so busy, and we do know a lot of subject matter experts. I see some of you here that have years of experience that could easily present one of these programs for CLE credits. The good news is you get double credits. That may explain why I'm doing basically two in a row, so I can get my double credits and satisfy the rules. But I would encourage people to reach out to the Bar Association if you want to present and get those double credits. That would really be cool. There's a reason why we present a lot of our programs in the second half of the year, because that's when people generally sign up, because you realize usually around November, December, you need those credits, right? So we have 4 programs coming up. The one that you're about to participate in right now. On the 26th, I'm doing one again. This is like a 1-hour program, and I'm really excited about it. It's about AI and the ethics of artificial intelligence, specifically large language models. I think it's called Algorithms and Advocacy, AI in the Legal System. I'll be presenting that on the 26th of November. So make a note of that if you're interested in how to use AI. And there are some ethical minefields with that. And then in December, on the 11th, we have a program with Warren Sutnick from Bergen, who's doing something on the changes in municipal court to driving while under the influence. Our president, Judge Damiano, will be on that panel. Chuck Festa is the moderator. We have someone who puts the interlock devices on. He's on the panel as well, and he can address the issues that arise in municipal practice about that. We got Hisham Masri from Redden and Masri, who's going to be the prosecutor on the panel. So on the 11th of December, the updates to driving while intoxicated laws. And then on the 18th, we have a diversity program. You got to get those diversity credits, right? We have a DEI program from my colleague Sue Curcio down in Atlantic County. And it's about complex juvenile delinquency cases, homicides, and the ethical and diversity issues that arise in those kinds of cases. So we have a full slate of programs coming in the next 4 months, and we're about to do one right now. So let me tell you a little bit about the guy who's going to present the information along with me about memory error and the issues surrounding eyewitness testimony in America, but especially in New Jersey. I started out at Montclair State in about the year 2000, but I met Jason maybe around 2006. And we immediately, realized we were kindred spirits. And I think he started talking to me about eyewitness testimony before he ever mentioned children in memory. But I was the child abuse prosecutor. So my interest was in how children's memories might get distorted by stuff, right? And Jason eventually became an expert in that, as well as in this aspect of forensics and memory, that is the impact of stuff on eyewitness testimony. And I'm proud to say we even did some research, some archival research together in 2007. We presented at a national conference. He eventually became my supervisor at Montclair State University, where he was the director of the Center for Child Advocacy. He was educated at Florida International University, where he got his Ph.D. He's got his MS and his BS from Central Michigan University. As I said, he was the director of the Center for Child Advocacy and eventually became the acting chair of the Department of Social Work at Montclair State University. He's a trainer with the Child First Finding Words program. And he also has a consulting program that he participates with about evidence-based interviewing training. He was a member of a task force that the Attorney General put together on clergy abuse and, you know, how to address those issues in New Jersey. I mean, he's written books, he's written articles. You know, when I was a full-time professor for about 2 years, I really liked hanging out with smart people. I really did. It didn't work out. I'm part-time professor now. But I'll tell you this, Jason's a really smart guy, and I am privileged to introduce him to you, and he can share with us what he's learned being a frontline, boots in the ground researcher about memory error, and specifically memory error in relation to eyewitness testimony in a criminal case. Jay?
Yeah, well, thank you, Joe, and hello, everyone. Thanks for joining, and my thanks to the Passaic County Bar for the invitation. I'm happy to speak with you today. I'm going to get right into it, so I'm going to share my screen here, and hopefully I'll get it to work on the first try. All right, can you guys see my screen?
We're good.
Okay. Okay. Yeah, thanks. Okay, so just briefly what we're going to do today, we're going to review a little bit of history and background on eyewitness recommendations. I'm going to talk a little bit about how research on eyewitness memory is conducted, and review some key recommendations from the current Attorney General's guidelines on collecting eyewitness evidence. And then Joe's going to give an update on some relevant case law. It's pretty straightforward. Currently, we believe that mistaken eyewitness identification is the leading cause of wrongful conviction in the United States. We still believe that, despite all the technology and improvements in recording, eyewitness evidence still plays a critical role in many investigations. And we do know that it is fallible to some degree, but at the same time, we really need eyewitnesses to make the system work in a lot of different ways. How we know that it's the leading cause of wrongful conviction really kind of goes back to the Innocence Project, which many of you are familiar with at Cardozo Law School. The project started by Peter Neufeld and Barry Scheck in 1992, and what they've done is looked at the cases of exoneration based on DNA. So these are really good reason to believe that these people were innocent. And if you go back and look at those cases, mistaken eyewitness identification was present in about 2/3 of those cases, which is pretty astounding. And there are other causes of wrongful conviction, but eyewitness identification has been the leading one. We don't know exactly how many wrongful convictions are due to, this eyewitness ID, but it's, again, quite a few. So in 1998, the American Psychology and Law Society, which is Division 41 of the American Psychological Association, published its first recommendations. They called it a white paper on reforms for collecting eyewitness evidence. So that was published in 1998, and that was quite influential. In 1999, the National Institute of Justice worked with APLS members and other folks, impaneled a group of defense attorneys and prosecutors from around the country. This was headed by Janet Reno. You probably remember her. They published the 1999 NIJ guidelines, which were federal guidelines. And as far as I know, they haven't been updated, but they were also quite influential. In 2001, the Attorney General's office here in New Jersey published its first set of guidelines, as far as I know. And those were in play for a long time, recently updated a few years ago. APLS in 2020 issued a new set, an updated set of recommendations, which are, all, primarily based on psychological science. And now what we're seeing is a lot of those recommendations are slowly kind of being integrated and updated into some of the current state guidelines, including New Jersey's, which I'm going to talk about today. So there's the URL for the current guidelines in New Jersey. They're not hard to find if you just Google Attorney General Guidelines, New Jersey, Eyewitness. You'll be able to find them well enough. So that's kind of where we are today. That's just a really brief history of the evolution of some of the guidelines. I want to just briefly talk about the research behind the recommendations in a lot of these guidelines. The first thing I want to talk about is called the trace evidence perspective, and this is really just sort of a recognition, really, that eyewitness evidence is really special evidence in a lot of cases. So just like the idea here is that just like we have procedures for collecting and preserving physical evidence, crime scene technicians go out and collect evidence and put it in a bag, and there's chain of custody, and then there are protocols for analyzing that evidence back when it gets to the lab. All of that is designed to, again, collect and preserve the integrity of that evidence. So the trace evidence perspective is just simply arguing that just like we need special procedures for collecting and preserving physical evidence, we also need special procedures for collecting and preserving eyewitness evidence, which was kind of the intellectual genesis of the current guidelines. There's also something in the science that we distinguish between. They're called system and estimator variables. System and estimator variables both reflect the different things that can impact the reliability of eyewitness evidence. The distinction is that estimator variables are things that law enforcement has no control over. Lighting, distance, the presence of a weapon, whether the witness is a bystander or a victim, the age of the victim or the witness, and I use those terms interchangeably sometimes. Law enforcement has no control over those things, so we can really only estimate their impact on memory. Most of the research has been on what we call system variables. System variables are things that the law enforcement can control. And because these are things we can control, this is where the recommendation come from. So these are things like the whether you conduct a show up or a lineup, or the format of the lineup. So all of the things that are encompassed in the guidelines we're going to talk about really represent system variables. But insofar as the research, this is kind of how we orient the different factors. We also have something called the eyewitness identification paradigm, which is basically a simulation. I think all of you are probably familiar with something like this from law school or have seen it on television. But basically what we do is we take a group of mock witnesses, we expose them to some type of an event where they see somebody commit a crime, essentially, a mock crime. And then we later give them a lineup to see if they can identify the person or not, that they saw previously. And so we present two types of lineups: the target present lineup, where the person that they saw is in the lineup, and a target absent, where is a lineup where the person isn't in the lineup. So that simulates the situation where the police have the right person. In other words, the suspect is the perpetrator. And then in the target absent lineup, the suspect is not the perpetrator. And this is valuable because we can look at eyewitness memory under different conditions using this model. And we also know the the right and the wrong answer. So we can, for example, in a target present lineup, we can look and see how often people get the right answer. In a target absent lineup, we can see how often they're wrong, and we can compare those two numbers under various conditions. In the real world, of course, when the police conduct a lineup, they may think that they have the right person, and they may very well, but they don't know 100%. But in the laboratory, we do. So I could talk about how we do this research for a long time, but I'm going to leave it there. There are some concerns that will come up, critics of this research, the concerns about external validity. External validity refers to the extent that our results from the laboratory generalize to the real world. Critics will argue that in this research, these aren't real crimes. The witnesses are not under stress. The consequences of making a decision when presented with one of these lineups are inconsequential. And there is certainly some validity to those criticisms, but I would argue that a lot of science is based on modeling, right? It's how we predict the weather. It's how we predict earthquakes, climate change, disease outbreak, right? So it's very common for us to conduct simulations to understand complex behavior in the real world. And the fact of the matter is the vast majority of the recommendations we're going to talk about today were derived from this research. So there are certainly ways to push back against the criticism about external validity. One really important concept that really isn't captured in the guidelines that I want to just briefly bring to your attention is this notion of evidence-based suspicion. So this is really, it's been around in psychology in the eyewitness research for a long time, and it's now just starting to get some traction out there nationally. But the idea is that before you conduct a lineup or a photo array, there should be evidence-based grounds to suspect that the individual is guilty of the specific crime being investigated, including that, before including that individual in a lineup or a procedure. And that prior evidence should be documented in writing ahead of time. And the idea here is that weak prior evidence contributes to high base rates of culprit absent lineups. So what this means is that if you don't have any prior evidence, or you have weak prior evidence that the suspect is the perpetrator, you're greatly increasing the likelihood of conducting a lineup that contains an innocent person. And the more you do that, the more likely you are to elicit a false identification. So the idea here is that you really should have, law enforcement really should have something beyond a mere suspicion before putting someone in a photo array. It's kind of like trial by ordeal. I mean, if you think about police interrogations, you don't, an interrogation it's accusatory. It leverages very sophisticated principles of obedience and persuasion. You don't just subject someone to an interrogation. Police shouldn't say, well, let's interrogate him, and if he breaks, then he's guilty. And if he's innocent, we'll let him walk away. It's not a diagnostic tool. So if you do that, you're increasing the risk of eliciting a false confession. So you got to have some prior evidence. Same thing applies to eyewitness evidence. And then I'm going to talk about the AG guidelines and some of the recommendations, but these are what at least I see as kind of the overarching goals of conducting an identification test, right? The procedure should be fair to both the witness and the suspect. The suspect should not unduly stand out, and the witness should have a fair chance to make an identification, assuming the perpetrator is in the lineup. And I'm going to talk, this is going to become relevant when we talk about how to compose a lineup. And the idea here is that you really want the lineup to be fair. The suspect shouldn't be immediately obvious, shouldn't stand out to a naive person. If you gave the lineup to a naive person and said, who do you think the suspect is? That person should be picked out about equally to all the other people. But the lineup members, the suspect and the fillers, the innocent people in the lineup, should not be so similar that someone with a good memory can't make an identification. It shouldn't be a lineup. Doesn't have to be a lineup of, it doesn't have to be completely uniform. Importantly, the procedure and its outcome should be documented and preserved. And if law enforcement cannot follow the guidelines at any point, that really should be documented in terms of what they deviated from and why they deviated from those guidelines. And that's an important point here. These are the Attorney General guidelines. That's what they are. They're guidelines. It's not a mandate. There is some room for flexibility, but it's important that law enforcement be prepared to document and defend why they made specific decisions if they deviate from the guideline. So again, here's just a screenshot of the guidelines. You can find the guidelines online easily enough. Also, on the Attorney General's website, there are instructions for using show-up ID procedures, and there's a worksheet in terms of how to document and record when you do a show-up and also a photo array. So those are also good resources for attorneys who work in this area, or prosecutors, detectives. These are two other important documents that I suggest people be familiar with, that aid in in documenting the procedures.
Jay,
Yeah.
distinguish between a show up and an array.
Oh yeah. So that's in the subsequent slides, but I'll address that now. The show up is a procedure where you present only one person, and that's the suspect. Now that could be in person, or it could be done with a photograph. So these are also called field identifications. And the typical situation in the field is the police are called, they respond to the scene, they have a description of the suspect, they canvass the area, they detain somebody, bring the witness to that individual and say, is this the guy? In other cases, the law enforcement just may show a photograph and say, is this the guy? So that's what a show up is. And I'll talk a little bit about some of the concerns around show ups. And that's different than the photo array, which can be done live, what we call a corporeal lineup, or a photo lineup where you have the suspect and then you have at least 5 fillers. The fillers are the known innocents, right? And the reason that we have fillers in the lineup is to absorb potential errors in memory. So if you have a witness who has a poor memory, you're not putting it all on one person like you would in the show up. So that's the distinction between the show up and the lineup. Composing the identification procedure. This is a really important one. Blind administration. The person administering the lineup should not know who the suspect is. And the idea here is that this removes any chance of bias on behalf of the investigator, whether it be explicit or through body language. If the person who's administering the lineup doesn't know who the suspect is, then there's no possibility that they can influence the witness's decision through the various means that I talked about. And of course, if you're doing a show up, this really doesn't apply. But this is an important recommendation. We don't really know the extent this is actually followed in the real world. You can imagine that some police departments that have limited staff may not be able to do this. But again, this is a key thing to look for. And if law enforcement can't do it, they should be prepared to document that they didn't do it and why. It's the same idea behind double-blind clinical testing of drugs, right? This is how you take the bias out of the experiment, out of the research. Another really important instruction, which has been around a long time, is before you administer the lineup, and this is captured in some of those forms that I talked about, before you administer the identification test, you should alert the witness that the suspect may or may not be present. And to borrow a phrase that Joe uses sometimes, it doesn't cost a nickel. It doesn't take anything, right? This is a very simple instruction. But what this does is witnesses will get a photo array and they will assume that not all the time, but they may assume that the police have the right guy, and my job is just to figure out who it is. So when the police alert the witness that, listen, we may not have the right guy, he may not be here, that just takes some of that bias out of the equation. So a very simple instruction. There's no excuse for law enforcement not to deliver this. The other major recommendation, which you may have heard about, is the simultaneous versus the sequential lineup. So the current guidelines recommend the simultaneous lineup or I'm sorry, the sequential lineup. But let me start with the simultaneous lineup. A simultaneous lineup is when you present all of the lineup members at the same time. They're all visible at the same time, and the witnesses makes their decision. The sequential lineup is when the witness makes they see one suspect at a time. They show one photograph. Is this the person? Okay, next, next, next. And the idea is that the simultaneous lineup tends to evoke what's called a relative judgment process. So they see all the lineup members at the same time, and they start comparing them to each other, and they pick out the person who looks most like the suspect. So it's kind of like a multiple choice test that you were familiar with in college, or maybe on the bar exam, where you think the right answer is there, the right answer is there, and if you don't know the right answer, you're just going to start using a process of elimination to find the right answer. The idea behind the sequential lineup is that when you're presented with just one photograph, the witnesses are more likely to compare that photograph to their memory than they are to compare the photographs to one another like they would in a simultaneous lineup, if that makes sense. So the sequential lineup, the psychological community really pushed hard for this for a long time, particularly Gary Wells, who's probably the world's foremost leading expert on this topic. He's in Iowa. He's a professor of psychology. And these are in the Attorney General guidelines, a sequential lineup. And this is derived on what's called the sequential superiority effect, this body of research finding that identification tests tend to be more accurate when the sequential format is used. However, I will tell you that the matter is far from settled. There was new science, new data analytics that came out, a lot of controversy in the field, demonstrating that sequential lineups may not be as better, superior to the simultaneous lineup. And actually, the new guidelines from the American Law Society, American Psychology and Law Society, do not push for sequential lineups, actually really make no mention of them, as far as I recall. So we have the recommendation for sequential lineups in New Jersey, but the science is not as cut and dried as a lot of people might think. Uniformity, again, the suspect should not unduly stand out, but complete uniformity is not required. Include only one suspect in each identification procedure. If you have multiple suspects, police need to do multiple lineups using different fillers. If you put more than one suspect in an identification procedure, you're increasing the risk of a false identification. So multiple suspects, you need to do multiple lineups. All of you probably remember the Duke lacrosse rape case from like 2006 or whatever. Some researchers wrote a paper about that case. It's titled something like "How Not to Conduct an Eyewitness Investigation." They made a lot of mistakes, but one of the things they did was they showed the alleged victim a composite of the lacrosse team, right? So it's like a picture like of the entire team, all their pictures, and said, okay, show us the people, right? And that was problematic because they're all potential suspects, right? Puts a lot of pressure on the witness to identify someone because the right answer must be there, but also you can imagine, I mean, you can understand that you're greatly increasing the risk of a false identification by presenting the whole team. Another recommendation, an important recommendation, is the fillers should be selected based on the witness's description of the perpetrator. So there's two approaches to selecting the fillers. There's match to description and match to appearance. When you match to description, you take a description of the perpetrator and select your fillers based on that verbal description that's been provided. When you match to appearance, you take the physical appearance, take a photograph, if you will, of the suspect, and you choose fillers based on how much they resemble that person. And what the research finds is that matching to description is superior, results in a better outcome. And again, you don't want a lineup of people who look so similar that it's impossible for a witness who has a good memory, got a good look at the perpetrator. We don't want to make it impossible for them to identify somebody. When a good description is not available, the fillers should be selected based on, that's the next point here, should resemble the suspect in significant features: gender, race, skin color, facial hair, age, distinctive physical characteristics. And that can be challenging too if you have a suspect who has a neck tattoo. But leave it up to law enforcement to figure that one out. The idea here is that the suspect should not unduly stand out. When you don't have a good physical description, the filler should resemble the suspect in significant features. The standard is to use a minimum of 5 fillers per identification procedure when you're doing a photo array. The guidelines recommend a minimum of 4 fillers when you're doing a live corporeal lineup. And when there's more than one witness and you need to show the lineup to more than one person, they recommend kind of mixing up the order, just in case there's something unique about the order in which they were presented. It's just another way to reduce bias. When showing a new suspect to the same witness, you want to avoid reusing fillers. That's pretty obvious. If you show 2 lineups and the only thing that's changed is the suspect, it becomes obvious who the suspect is. Ensure that no writings or information concerning previous arrests will be visible to the witness. I saw a lineup form that had been completed once, and they had, I saw the lineup and they had the date of the arrest written underneath all of the people, and there was only one guy who had been arrested that week. So law enforcement should make sure that there's no writing, and then view the array once completed. Just give it a visual check to ensure that suspect does not stand out. preserve the presentation order of the lineup and preserve all the photos in their original condition. And also, if you're doing a corporeal lineup, a live lineup, which actually just helped a detective in Michigan recently put together a live lineup, and I was able to watch it yesterday on Zoom. She booted up the video because it was recorded on body cam. You know, that they didn't take pictures of the individuals, but you got to see the entire lineup recorded on a body cam. That's the idea. That's the goal, is to preserve the order and preserve, you know, some type of physical record of who these people were and who they look like. Avoid repeating identifications. This is an important, this is a really important recommendation. Repeated identifications can create contaminating carryover effects between procedures. So this sometimes happens, for example, when the police will do a show up and then a week later they'll do a lineup with the same suspect. Or they'll do multiple lineups for whatever reason with the same suspect. And the problem is that becomes suggestive, and it increases you know, the likelihood for a false identification. And this can, you know, as far as the witnesses are concerned, this can happen a couple of different ways. They could explicitly see this as bias, right? So the police are showing me this guy twice. It must be him. So I know that I've seen this guy twice now, therefore it must be him. That's not a great situation. And then there can also be this implicit bias, which is, this guy looks familiar, it must be him. And this has to do with a psychological concept called source misattribution. So source monitoring is your ability to identify the origin of your memory. Where did you acquire knowledge? Where did you acquire information? Where have you seen something before? Did you actually experience something or not? The example I always give in training is a very mundane example. If you have ever can't remember who told you something, that's a source monitoring error. If you've ever left the house or the apartment and wondered if you turned something off or locked the door, that's a source monitoring error, right? So we're all prone to this to some extent. So what can happen in this situation is they see the suspect in a show up, for example, and then they see him later in a lineup. They don't really have a memory, an explicit memory of seeing him in the show up, but he does look familiar because they know they've seen him before. So they, you know, it must be him. So it's a form of suggestion. It's suggestibility, essentially. And this has to do with another important concept in memory, the difference between familiarity and recollection. So all of us have probably had a situation where we've seen somebody, we've met somebody, and you say, wow, I really know this person. They're very familiar to me. I know I've seen them before, but I can't place where, right? Because you haven't encoded the context. There's no context that attaches that memory of that individual to a specific situation. In other cases, we see somebody and say, oh yeah, I recognize this person because X, Y, and Z, right? That's the difference between familiarity and recollection, or, when, well, I guess you get the idea. You have attached some type of context. So really what we want the identification to be based on is the witness's memory for the crime, not their memory for having seen somebody previously outside of the crime scene, right? And when you do a repeated identification, that can happen. The Attorney General guidelines have a fairly lengthy section regarding mug book identifications. So a mug book identification is where the police just like open up a database, could be an electronic database, or, you know, I don't know if they have actual literal mug books anymore, where the witness is just flipping through to see if they recognize anybody. And all of that should be documented. The Attorney General guidelines go to great lengths talking about how mug book exposure should be documented. And you can imagine that if they see somebody familiar to them in a mug book, and then they later are given a lineup with that individual, the things that I've just talked about on this screen are, you know, potentially at play. So this is a big one, avoiding repeated identifications. What's going on with my screen? Okay, recording confidence. This is another really important one. A confidence statement should be collected immediately after an identification. And to borrow another phrase from Joe, what does immediately mean? It means right now, right? It means right now. Immediately after the identification, law enforcement should collect a confidence statement. And this is really important, first of all, because jurors put a premium on witness confidence. As you can imagine, in the courtroom, the prosecutor might say, how confident are you that this is the guy? What that juror says is going to be or what that witness says is going to be persuasive to the, you know, to the jurors. That's just intuitively, it's a very strong indicator of accuracy. How confident are you that you're accurate? I'm 100%. Well, then that's what I'm going to go with. Why wouldn't I? The fact of the matter is, the research clearly demonstrates that confidence is malleable. So, for example, there's been research that has demonstrated that if you provide confirming feedback after an identification and then later take a confidence statement, if the investigator says, yes, that's our guy, you know, good job, we got him, you know, that's him, that sends their confidence through the roof. And it also can literally change their memory for what they saw. Witnesses will now report getting a better look at the guy. They will report having looked at him longer, right? These have all been done in controlled research studies. So the idea here is that confidence is very important, but you want to capture it immediately after the identification before any influence can be brought to bear on the witness. And that becomes part of the record. So when you go in court, you've got that confidence statement at the time of the identification, and that's the evidence, not their confidence at the time when they're in the courtroom where they've been, you know, 6 months later telling their story to all their friends and whatever. So the lineup that I viewed yesterday, they were doing it was a 10-year-old cold case, rape case. It was a 10-year-old rape case. And it was a live sequential lineup in one of those rooms like you'd see on TV, like glass on the witness on one side and the lineup on the other side. They brought them in one at a time. When they brought in the suspect, the witness really quickly made an identification, and the detective, who was not the primary detective, who did not know the suspect's identity because it was a blind lineup, she immediately recorded the confidence statement before they moved on and did anything else. Before the victim saw the rest of the lineup even. So that's a really important. So when I say immediately, that means immediately. Um, uh, so, yeah, so this is a big one. And importantly, there's no standard language for how to collect a confidence statement. The detective might just say, how confident are you? Yesterday in the lineup, she said on a scale of 1 to 100, how confident are you? And in this particular case, the victim said 100%. I like that question because it provides, it's more quantifiable than, oh, I was very confident. But there is no standard language for how to collect a confidence statement, unfortunately. We talked a little bit about show-ups before. The show-up is the presentation of a single individual. There's no filler. They are inherently suggestive because there are no fillers. So this single person that law enforcement is presenting is obviously the suspect. And it has a potential for higher error rates. So because there are no fillers, you can imagine when a witness identifies a filler, it's a harmless error, right? It's an error, but it's inconsequential. But if the witness makes a mistake, if they make an identification using a show up, it's always going to be, and the suspect is not the perpetrator, it's always going to be a false identification. And for this reason, I'm not a lawyer, I'm not a detective, but generally, show-ups really should be avoided unless there are exigent circumstances that really dictate their use. If there's some reason to, if there's an immediate need to do an identification, something like that. The problem is that once you've done a show-up, you can't really do a later lineup. So the AG guidelines say that a show-up should not be conducted if more than 2 hours have elapsed between the event in question and the time of the identification. Okay, a note on corporeal lineups. So a corporeal lineup is a live lineup. And I think this was more common in days past than it is today. There's still kind of a prevailing notion that live lineups are superior, because when you see somebody live, you get a lot more information about that person. You get to see exactly how tall they are. You might be able to see how they move. You just get more information. But there's little evidence that corporeal lineups are superior to photo lineups. And the corporeal lineup is much more difficult logistically to put together, to execute, and to control for extraneous factors. So, that's something to think about as well. You got to get the fillers and the suspect all in the same place at the same time. There's potential for contamination. There's potential for overhearing conversations, so on and so forth. So, suffice it to say, they're much more complicated to do, and there's little evidence that they're superior. I don't know the law in New Jersey, but the law in Michigan, where I've done quite a bit of work, they have a law that says you should do a corporeal lineup if the suspect is in custody, unless there are exigent circumstances. But as far as I know, they don't have that rule in New Jersey. So I'm sure that the vast majority of lineups here are photo lineups, which I think is just fine as long as they're done well. That's just my opinion based on the research. I have just just a few more minutes here, and I'm going to turn it over to Joe. I do want to mention too, the kind of growing interest in conducting eyewitness identifications with children. And I'm not talking about child suspects. I'm talking about how children view lineups. There are the guidelines, the Attorney General guidelines and other guidelines out there are really written for adults. They don't really consider children's developmental needs or their cognitive limitations. And what we know about children, first of all, is children give relatively poor physical descriptions of people that they've seen compared to adults. Their physical descriptions are oftentimes just not that helpful. That's one thing to think about. The other thing too is that a lot of children, one of the reasons there's kind of a gap in this research and policy around children is that in the vast majority of the cases, perpetrators are known to children, right? These are cases of abuse and neglect and things like that. So, children are much less than adult are the victims of, the proverbial stranger jumping out of the bushes type of scenario. So what we know about children's performance is their performance, and when I say children, I'd say probably children under the age of 12. They perform worse than adults. They're less likely to identify a perpetrator from a lineup, a guilty person from the lineup, and they're also more likely to make a false identification from a lineup than are adults. It's not to say that their decisions don't have any probative value or they can never be trusted. They just underperform compared to adults. And one of the reasons is that children like to choose. They're just not very good at saying someone's not there. And instructions like he may or may not be there have really not been particularly helpful for mitigating their propensity to choose. So there are some special considerations when it comes to children. The most common situation, I think, working with children's advocacy centers nationally and things like that, is where you've got a suspect who's well known to the child, so that in many cases, the suspect, for example, is mom's boyfriend who lived with a family for 5 years, and she's like, there's been a cast of characters who've been in and out of the house for the last decade, right? So the child says, Uncle Bob, or mom's boyfriend abused me. What's his name? His name is, Bob Jones. He lived with us for this long, and here's when he lived with us. And in those cases, it may be relevant for law enforcement or law enforcement or whoever to just show a single photograph. It's confirmation. Is this Bob Jones? It's different than a lineup. You're not developing a lead. You're just confirming that this is the person that the child is in contact with, if that makes sense. And I don't mean to bring that up. I mean, and not talk about it more, but suffice it to say, the eyewitness identification around children is, there's a lot of different contexts and a lot of different there are several different recommendations we might use with kids. Unfortunately, there's currently not a lot of policy guidance when it comes to kids, but kids, they witness homicides, they witness all types of things. So that's important to kind of keep in mind. The final thing I'll say is, if you have any questions after today, I'm not hard to find. I'm at Montclair State. You Google my name. Happy to, if you have a question or whatever, happy to chat. And with that, I'm going to turn it over to my esteemed colleague, Joe. And I got to figure out how to quit sharing my screen here. Give me a second. Oh, there we go.
Joe, you're on mute.
Am I unmuted now, Jay? Abraham Lincoln. Abraham Lincoln. Yeah, there's a lot of science that provides the underpinnings for court cases that arose around 2011. And Jason hit on most of the high notes. And I'm going to take a look at, where we have gone in New Jersey specifically with regard to the science of memory error and eyewitness identifications. But before we start that, I just want to open with a couple of war stories just to address the issues from my perspective, having been a trial prosecutor for nearly all of my career. And, early in my career, I was trying adult cases. Most of my career, I tried cases that Jason referred to at the end of his presentation, children who may have been abused and neglected or exploited. But I had a fair share of adult survivor cases, adult victim cases. And I remember the great Judge Leapese once presided over a Wade hearing. Wade is the original leading case on identification and what the police should do and what prosecutors should do in demonstrating the reliability of an out-of-court identification. And the Wade hearing before Judge Leapese involved the Dominican travel agency robbery. And that's what we called it around the office. And it was interesting because the defense lawyer made a very powerful argument. Of course, I rejected it, but she made a very powerful argument because the person who was robbed, who was the accountant, said in his description of the assailants, and he gave a number of details upon which to make an identification, but he said it was a Peruvian guy or a South American guy. And when the photo array was constructed, the detective who created the photo array created an array that had 8 Hispanic males with the similar complexion, similar hair, similar eyes. Everything was similar except for the facial structure. And in that lineup or that photo array were 7 Caribbean Latinos and one guy who was a South American Latino, the suspect, the guy that the police thought did it. And of course, they identified the man who was of Peruvian heritage. And the attorney for the defense argued that the facial structure of the South American Latinos looks very differently from a Caribbean Latino. And experts would argue that that photo array, that the 8 people had what they call the functional equivalent of 1, because when the person looks at it, they eliminate the first 7 immediately because they don't have the facial structure of a Peruvian, which based upon their heritage has a very distinct, almost moon-like in certain circumstances. The cheekbones are different, the jawbone's quite different. And among Latinos, they can spot it right away, and it was a Latino victim. So Judge Leapese rejected that, and we were able to go forward with the case. But I remember Kevin Ronco coming to me and saying, listen, that didn't look good, that ID, and he wound up pleading it out. I believe we had the right guy, but the photo lineup was not constructed properly. And although the defense lawyer didn't convince me or Bruno at the time, I understood in the ensuing years that that was not a quality lineup, hardly a quality lineup. And later on, when I was in the sex crimes unit, I tried a rape case. And some of you may remember this case that I tried. It was the case that I kind of learned the craft of being a trial lawyer. It was the Joe Logman's rape case. And Joe Logman's had a striking resemblance to the movie actor John Candy. And that case involved a stranger rape where identification was vital. And the identification was done by the detective from North Halden, Alan Swartz, and it was a photo array. The difference between dealing the images on photographs, like a deck of cards. This was 10 images presented at the same time. Jason was just talking about that. The problem was Joe Logman's looked so like John Candy, the movie actor. He was what they call him, a doppelganger or whatever. He was so similar to John Candy that none of the foils or fillers could look like John Candy. And, Cal Geist had a reputation. He was my adversary in this case. Cal had a reputation as a vicious, aggressive, assertive attorney. Brilliant, but assertive, aggressive, and a ferocious cross-examiner. But some might forget that he was someone who made sure that he used all the best kind of expert witnesses of his time. And he brought in experts in that case. That's how I met Dr. Stephen Penrod. Penrod's a giant in this field. Jason, who just presented now, has been doing this research since the 2000s. Penrod's been around since the 80s. There are others as well, Elizabeth Loftus and Michael Nash and Thomas Albright. But Cal brought in Dr. Penrod from the University of Minnesota, and he was an expert on memory error and identification. And we're talking the mid-90s now. This was my first exposure to memory error and eyewitness identifications. And he said that the photo array had the functional equivalent of 1. In other words, it was a lousy photo array because the only guy that looked like John Candy was Joe Logmans. The viewer, in this case, Jody, the victim, would look at it and immediately pick out the guy who looked nearly exactly like John Candy. But the problem was, how do you remedy that when you have a distinctive look, right? And there's some research on this. The detective did the best he could, but in the mind of the expert, on memory error and the composition of photo arrays, he concluded that this was a junk photo array. The only person who really looked like John Candy was the suspect. Nevertheless, we went to trial. He got convicted and he went to jail for a long time, and he was the right guy. There was a lot of other things that tied him to the conviction, to the case, and it was appealed up and down. And had there been only the ID that supported his guilt, then he probably would have won at the appellate level. He didn't, and he went to prison for a while. In that case, I also met Barry Schenk from the Innocent Project. Cal brought in Barry Schenk. Barry Schenk is at Cardozo Law School. Jason talked about the Innocence Project. They did a lot of the early research, and they continue to do research where they look at erroneous convictions, right? Erroneous convictions, people who are innocent but were convicted, and they exonerate them primarily based upon DNA evidence. So they brought in Barry Schenk, and he didn't move the needle very much in the Logmans case for a variety of reasons, because we had other compelling evidence. When you just have the ID, the potential for an erroneous outcome is significant. So when you build a case, you try to build a case as a prosecutor beyond simply the ID. You got to get that physical evidence that connects the person to the crime. It's very valuable. ID evidence, eyewitness evidence is overrated. I thought that as a prosecutor. I think that now as a defense attorney, and I think that as an academic. And I think Jason did a nice job of explaining why the potential for eyewitness evidence to be persuasive is often overrated. And one thing about New Jersey's pretty cool with relying on science. They relied on the adolescent brain research in determining whether juveniles should go to jail, how long they should go to jail, the development of the adolescent brain, the prefrontal cortex, and all that in deciding issues surrounding juvenile justice in New Jersey. And so did the United States Supreme Court in Miller versus Alabama. Point being, there's all this science out here. There's all these Jason Dickinsons of the world and Dr. Penrod who are doing work in colleges and universities about memory, about forensics. And New Jersey has been quick and steady in their embrace of the science. And the first case in eyewitness identification that relied almost exclusively on the science, just what Jason talked about, is the case that's on the screen now, State versus Henderson. This was a big deal. I was still in the office in 2011. I remember reading this case, and I remember reading the Attorney General guidelines, and we had to change everything about how we took a victim who was victimized by an unknown assailant and presented her with possible perpetrators. We then had to change from these photo arrays under the Attorney General guidelines and deliver the pictures like a deck of cards, one at a time. And as Jason pointed out, the guidelines still require that. Jason shared with me, and I didn't know this just about 15 minutes ago, that the research is now suggesting that that's not superior than the old school photo array where you give somebody 10 pictures at once. There's no conclusive evidence as to which one's better. But I'm sharing with you, in New Jersey, the AG guidelines are pretty clear. You do it sequentially, one after the other. And if I remember correctly, You bring in a detective who doesn't know anything about the case, so they can't impart bias or suggestions, at least in theory, to the survivor or to the witness, whoever it might be. And when you deliver the images, you tell the person, listen, even if you see the person, don't tell me yet. I want you to look at all 12 people. So there's a very specific and rigorous way of doing this. These Attorney General guidelines are available online, and law enforcement knows about them, detectives know about them. All of that, all of these guidelines are a result of the research that Jason pointed out, and this case, State versus Henderson, which was a big deal, and it continues to be a big deal. So what happened in Henderson? So Henderson involved a defendant who was an unknown assailant, right? That's the kind of case you would expect, where you have a photo array. The victims of this robbery homicide were attacked in part by one of the assailants who no one ever saw before. They didn't know who he was. There actually were, I think, 2 or 3 people that broke into the house and committed the crimes, ultimately resulting in the death of one of the people at the house that day. But the person who was in the Henderson case, Henderson, was an unknown assailant. The non-lead investigator showed the witness 8 photos, one at a time. So even back then, before Henderson, the sequential presentation was utilized. There were headshots of African-American men, right, 8 of them, and they were between the ages of, I think, 20 and 35, and they fit the description of the witness. Short hair, goatees, similar facial features. The witness who was at the police station, I think this was Newark, I'm not sure. No, it wasn't Newark, it was some other municipality. But the witness immediately eliminated 5 pictures. These 5, not the guy. The other 3, he focused on a little bit more. He discounted 1 more, and he wasn't sure of the 2 final pictures. So now you're left with 2, right? You started with 8. He blows off 5. There's now 3. One of them, he says, that guy's out too. Now you're left with 2. And he doesn't make a positive ID. So what happens next? You know, bad cases make bad law. 2 investigators come in the room, 2 other detectives. So you got the detective who wasn't part of the case. And they don't say whether one of these 2 investigators was the detective whose case it was, who has an interest in the outcome. But anyway, 2 other cops come in the room and they tell the witness, you're holding back. I know why you're holding back. You're afraid of retaliation. You think the gangs are going to come after you, or the bad guys are going to come after you. Another investigator tells the witness, don't worry, we can protect you, man. We can protect you from retaliation. Just pick out the guy. Pick out the guy who did this. The investigator also told the witness, just do what you're here to do. After they left the room, he immediately goes, that's the guy. And thus you have the Henderson case. You know, Henderson gets prosecuted based upon that factual scenario. When the trial went down, we learned a few other things. The witness that eyeballed and fingered Henderson was smoking crack and drinking alcohol the night of the shooting. And when he made the identification of Henderson, he was mostly, if not the entire time, in a darkened hallway without good lighting. Okay. And these are the things that Jason talked about earlier about the system variables, okay, and the estimator variables. The estimator variables are the things you can't control. When the detectives got this case, the guy was in a dark hallway when he saw the guy. Can't change that. Cops don't have any control over that. Guy's in a dark hallway. But it's a fact. So the witness was on crack and alcohol. He's in a dark hallway. There's a gun pointing at his chest. One of the things I learned about in the Logman's trial was something called weapon focus. And if you look at the research in greater detail here, there's a strong body of this research that says that when people have a gun pointed at them, they're not too good at identifying people compared to people who don't have a gun pointed at them. They call it weapon focus. You know, your eyes are on the gun, they ain't on the face. The face becomes less important. Therefore, the accuracy of you telling us what the guy's face looked like is diminished when there's a weapon involved. So the guy on crack, guy on alcohol, it's dark. There's a gun pointed at his chest. Those are estimator variables. Cops can't change that. Them the facts, right? When he comes to court, the witness, he makes an in-court ID. That's the guy. That's the guy. These in-court IDs, as Jason pointed out, can be overrated. Often the confidence level gets higher and higher as the trial approaches. God knows, you know, who talked to him between the time of the original photo array and him putting his hand on the Bible or affirming, right? So now his confidence level's up. Jurors place a premium on in-court IDs, and the witness in Henderson made a very powerful identification in the courtroom. Problem was, different from my Logman's case, there wasn't much physical evidence, if any, that connected Henderson to the home invasion and the killing. So all you had was the witness's ID, and it was a shaky ID, I would offer, right? You saw what happened. He was left with two guys. The cops came in and, you know, they were attempting to be sincere about it. They felt that he was afraid of the guy. And if the guy was a gang member or whatever, he felt that the guy was intimidated. But that creates a problem, nevertheless. Obviously, the two officers come in and they start to pressure him in the middle of the photo ID. Not a good idea. And as Jason pointed out earlier, we are obligated to take good notes. When I say we, law enforcement is obligated to take good notes about any colloquy, anything that was said during the identification procedure, including the dynamics of where people are standing, what they said, their connection to the case, and those kinds of things. As you might expect, we wouldn't be talking about this case. He was convicted of manslaughter, got 11 years in jail, Mr. Henderson. So the time was right. You know, Jason gave us the history going back to the 90s. I mean, I cross-examined Dr. Stephen Penrod in the mid-90s. So this was a thing in the mid-90s. Memory error, the inadequacy of eyewitness identification was a thing in the mid-90s. And you had the leading people in academia who were studying this stuff. But it wasn't until about 2007, 8 that the courts started to dip their toes into the science, maybe be influenced by the science. And as I suggested earlier, you know, Jersey's pretty good with accepting science in their decisions in a lot of contexts. Well, the time was ripe in 2010, 2011 in the Henderson case for the New Jersey Supreme Court to respect and ultimately to embrace the science on memory error in out-of-court eyewitness identifications. And it was so complicated. This issue was so complicated that the New Jersey Supreme Court did something that courts do when there's really significant, let me minimize this, when there's really significant issues involved and they don't really understand science or excuse me, there we go. When it's a really sophisticated problem, the court will sometimes appoint a special master, and that's what they did here. Once they read the briefs, the American Psychological Association, the Association of Criminal Defense Lawyers, you know, the County Prosecutors Association, the National District Attorneys Association, there were briefs. Over 200 published scientific studies were presented to the court as exhibits, more than 360 exhibits, scores of articles, scores of amicus briefs, and the Supreme Court said, oh, time out. We're going to appoint a really smart, usually former judge to take a look at all this stuff and do a remand hearing. We don't know whether we should embrace this science. Is this science persuasive? Is it legit? Is it junk science? Is it real science? So they appointed a special master, and there was a 10-day hearing, and the special master heard from everybody. Expert witnesses testified over 10 trial days, including law professors, psychology professors, career investigators and detectives, career trainers of law enforcement. There was people from law enforcement, people from psychology, people from the defense. And after 10 days, the special master finally issued a finding. And the finding was this science is real, it matters, and we need to take a good look at the way that we evaluate out-of-court identifications and the process that law enforcement engages in. And the process up until the Henderson case was based upon a case
Abraham
called
Lincoln.
Manson, two
Abraham
cases.
Lincoln.
It was the Manson-Madison test, okay? And there were two cases. Pretty sure they were federal cases, not New Jersey cases. But after the special master heard everything and presented his findings to the Henderson Supreme Court, the Supreme Court accepted them and abandoned the Manson-Madison test. And they promulgated a new test. And they were clearly influenced by the research and science in the field, all the things that Jason talked about and his predecessors who study this area in academia and in psychology and in research. What was the Manson-Madison test? Well, the first prong was, now this is the test they got rid of. This is the way it used to be before Henderson. The first prong was, you know, when you're in court and the prosecutor is trying to defend this identification, trying to get in the out-of-court identification, to get in the fact that the victim said in the police station, that's the guy who attacked me, okay? Or in the Henderson case, that's the guy who shot my friend and killed him. If you're trying to get that information in before the jury, you're going to have a plenary hearing, you have a 104 hearing in front of the court, pretrial hearing, and you have to show under Wade that the evidence is admissible. The first prong under Manson-Madison is you had to show, the defense has to show that it was a demonstrably flawed identification. And if you get to that, if you get in the door as a defense lawyer, you get on to the second prong, and the court was for years instructed to look at the following factors. And I argued these factors under Neal versus Biggers and under Manson-Madison in the 90s, because this was the rule of law at the time in the Logman's case. I remember during a break in action, Larry Lussberg, who's a rock star defense attorney. Some of you know Larry, he teaches at Seton Hall. He's a defense lawyer, former president, I think, of the Defense Lawyers Association of New Jersey. Larry Lussberg saw me in the hallway, probably pale white, terrified of this trial. You know, it was a big deal. It was well attended. It was covered all over North Jersey and New York. And, you know, he said, listen, relax. Just focus on Neal versus Biggers, okay? Which is basically what the second prong is. Just focus on that, Joe. And when you argue to the jury, highlight what? The witness's opportunity to view the perpetrator at the crime scene, the degree of attention, the accuracy of the description. You know, in that case, Jody gave a very specific description. And then when we picked up the primary suspect, he looked just like her description, right? So you look at her opportunity to view the perpetrator, the degree of attention the witness had on the perpetrator at the time. Was it a dark hallway? Was there a handgun in her belly? No. I pointed out to the jury in the Logman's case, she was in the woods with him for 7 or 8 minutes. Then she managed to escape. She looked him in the eye. She had a conversation with him about life, about religion, about why would he do these things. And then he released his hold on her and she ran away. So as Larry pointed out in the hallway, I was able to focus on the degree of attention and the accuracy of the description. And the time that elapsed is a big deal. And it was a big deal under Manson-Madison. And these are good things, but they're not enough. There are other factors involved. And certainly we talked about, no pun intended, the certainty of the witness's identification. This rather limited test, while it was good stuff, wasn't enough. And that as the sole barometer for the quality of an out-of-court identification was abandoned by the Supreme Court in Henderson. The Supreme Court felt that Manson-Madison does not adequately allow for the analysis of variables. Now remember, Jay talked about this, system variables and estimator variables. System variables are what the cops do or what law enforcement does. These are things the police can control. What kind of pictures they provide, whether they're sequential, whether they're in an array, whether they're in a live presentation, right? What the people look like. Are they one Peruvian and, you know, 9 Caribbean Latinos? You can control system variables. You know, what you say to the person during the presentation is something in your control, law enforcement, right? Those are things that matter. Estimator variables, by contrast, are things you can't control. I told you before, the guy got attacked in a darkened hallway with a gun in his chest, right? You can't control that. That's what happened, right? These are factors which are generally outside the state's control, but they're related to the individual and the event. Research has told us, and the Supreme Court said, we have to look at all this stuff now. Manson-Madison doesn't look at enough. The court concluded that it did not offer an adequate measure of reliability, and it didn't sufficiently deter inappropriate police conduct. It relied too heavily on the juror's gut to evaluate identification evidence. This is a sea change. And by sea change, I mean, this Henderson case was a big deal for a variety of reasons. But one of the most important reasons was, and this is still the rule in the federal courts, the only focus prior to Henderson was on what the police did. That's it. Because the Constitution really is directed at government action, right? State action. That's what a Constitution is. But there are other grounds for the Supreme Court, including our state Constitution, to issue its opinion. and decision. But up until Henderson, the question of whether it was a quality out-of-court identification focused on what the cops did. Was it a good lineup? Did they put ideas in the victim's head or the witness's head? Now it's on a lot of things. It's not only on police conduct. This is a sea change, a significant change, a big deal. It hasn't changed in the federal courts, unfortunately. But New Jersey, among the more liberal states, ones that are more open to psychology and science, we now have a process which looks at everything, both the system variables and the estimator variables. So what's the new test? You know, they abandoned the Manson test, okay, the Manson-Madison test. What's the new test? Well, New Jersey Supreme Court in 2011 said, listen, the initial burden is still on the defense lawyer. You have to show some evidence of suggestiveness, some evidence of a problem that could lead to misidentification. It must generally be tied to a system variable. So the starting point hasn't changed too much. You still have to point to something that the cops did that could result in a misidentification, something the cops did that might create memory error. That's what Henderson says. That's still the focus as of 2011. System variables, things in police control. But if you're able to show that, if the defense lawyer is able to show that, then the state has to offer proof that the identification is otherwise reliable, accounting for both system and estimator variables. Then the dark room, the gun, and all that stuff becomes even more important. The court can end the hearing at any time that it finds the allegation of suggestiveness is groundless. You know, once the court takes a closer look at it, if the defense lawyer said, this was highly suggestive, and a third of the way through the plenary hearing, the court goes, I'm not feeling that. I don't get it. This Wade hearing's over. You know, they can do that. I don't know how often that happens. That's kind of an invitation to be appealed and lose. But you have that authority, according to the Supreme Court in the Henderson case. The court can suppress the identification evidence. You know, conversely, they can suppress the identification evidence if, after weighing the evidence, looking at the totality of the circumstances, there's a very substantial likelihood of irreparable misidentification. And if the evidence comes in, there's a new jury instruction that Henderson provided, and it's been changed a few times since Henderson. Here are some things. I'm not going to go over every one of these, but when I talked about system variables, what are the kinds of things that the police are in control of? Well, did they have a cop who wasn't the case agent do the lineup or the photo array? If they had the guy whose case it was do the photo array, you're in charge of that. That's not a good thing. That's a problematic thing. So these are the things that the court said you have to look at. Were the instructions proper? Was the lineup constructed? Where it was one Peruvian guy and, 8 Dominicans? Was there feedback? Was there improper feedback? Again, something law enforcement's in control of. Did the administrator record the statement of confidence? Jay talked about confidence. Did they record it shortly after the identification? Or did they write it down a week later? These are things that the court's going to look at. And if you could point, as your defense lawyers who are in this program can look at these things, and if the police didn't follow these things religiously, you got the beginnings of the basis to get a hearing. If you can't point to one of these things, you're probably not even going to get a hearing. But you know what? The police aren't perfect. Almost always you're going to find something among these 9, and it's not exhaustive. It's illustrative that might get you in the courtroom on a Wade hearing under the new Henderson standard. Their confidence, are there multiple viewings? Was this a show up? Were there private actors? Did the cops say, listen, I talked to your sister who was also there, and she said the guy who did this, he looked like he had dark hair. You can't say that. You're not telling who to pick, but you're saying something about what another witness told you. That's a major no-no. That's a major no-no in child abuse investigations and in forensic interviewing of children. It's a major no-no here as well. So you want to look at all these things. In the Henderson case, you had the police stick themselves in the middle of the lineup, in the middle of the photo array, and start telling the guy, listen, we think you're lying, basically. We think you're a liar, and we're the cops, and we have power, and we can defend you, man. Tell us who did this. I know why you're lying. I know you're lying because you're afraid. I mean, what they were doing on the surface is noble. They're telling them, listen, you don't have to be afraid of the bad guys, the gang members. On the other hand, though, assume that he doesn't really know who it is. He's feeling pressure to pick a guy out. Not ideal. No surprise that the Henderson case was reversed. Estimator variables. You know, this is about the dark room, about the gun, weapon focus. I just brought that up. How long did you look at the guy? How long was the observation? What was the lighting like? These are things the cops have no control over, right? These are things that arise from the event itself, from the scene. And they matter too. Once you get your foot in the door, defense lawyers, then you focus on not only the system variables, but these variables, the same ones in the 90s that I brought up in the Joe Logman's rape. The lighting, the duration, you know, there was no weapon focus, bias, opportunity to view the person, degree of attention. These are similar, not exclusively like the original test. There are other estimator variables that need to be considered. So that's Henderson, right? Henderson gave us a new rule. It abandoned Manson-Madison, and it gave us the new rule I just gave you. There's been a lot of action in this area in the past 5 years, okay? A lot of action, because cases have come up from the trial courts and the appellate courts where there have been questions about whether Henderson was dutifully followed or whether something that Henderson didn't address is relevant and ought to be integrated into the Henderson decision. So one of the issues after Henderson was about record keeping, and we all knew that you had to write down some notes. But now, post-Henderson, those notes have to be virtually verbatim. Whatever notes you have, they need to be copious and verbatim. Whatever you said, how can you really evaluate the system variables if there's no record of what happened? So there's an obligation to take a verbatim, a significant, a really diligent record of what happened and keep that record. What did the array look like? What was said before? What was said after? What was said during? What were the pictures look like? What was given first? What was given last? What did you say? What did they say? So State versus Green in 2019 said, listen, to allow for appropriate review of an out-of-court identification procedure that used, in this case, well, I think this was a digital database case, but anyway, any case that it uses a computer to show pictures or the old school paper mug book, administrators should preserve the photo of the suspect the witness selected, along with any other photos on the same screen or page, and any photo that a witness says looks similar to the suspect. So if you have a witness looking through 100 pictures, you don't have to save, you should save all 100. That's best practice. But what they're most concerned is the page that the person was on and the fillers that were around him. If he was on a page with 30 people and you showed 500, then the person with the 30 people needs to be documented and preserved. And if anywhere in the mug book, we don't really use mug books anymore. Most officers use computers now. The administrator should save the screen or the collection of images of persons that the witness says, that kind of looks like him. And that's Green, that's new. Green also addressed an issue that Jay brought up in his presentation, and the memory carryover effect, duplicate images of the defendant. See, in Green, you know, what happened was Green used something very fancy. And I think it was about 4 or 5 years earlier. This was Newark PD, and they had a piece of software called DataWorks Photo Manager System. So they had something really fancy where they used software to show pictures or images of potential targets and fillers. It is a high-tech Wade photo sequential way to present pictures. And what happened was, there's two views. You know, in PowerPoint, I have presenter view and I have design view. Well, when you're using that software, the detective has investigator view, where he can look at all the potential perpetrators and people who look a certain way. And then when you're with a witness, you got to click on witness view. Well, the cop forgot to click on witness view. So what happened was Green, Mr. Green, lawyers, not that Mr. Green, the Mr. Green in this case, Mr. Green appeared multiple times. Not okay. To guard against misidentification, the Supreme Court in Green said, we place on the state the obligation to show that the eyewitness was not exposed to multiple photos or viewings of the same suspect. And it's perilous when you use a mug book when the guy's been arrested 2 or 3 times. So that guy could be there 3 times and everybody else is only there 1 time. That's a problem, as Jason pointed out, as research tells us, and intuitively. I mean, you don't have to be a fancy researcher like Jason Dickinson, to figure out that the more you see the picture, the more it might tamper with or, distort the recollection of the person who's the witness or the survivor of sexual or physical violence. After Henderson, you got another case called Anthony, State versus Anthony. Again, these are the cases that extrapolated from Henderson, that extended Henderson. Anthony's about video recording now. And Anthony, same court, about the same time as the Green decision, the Supreme Court said, listen, you got to record the identification. We're not liking what we're seeing. Cops are not completely recording what's happening here. And we are now saying that we want you to video record it. If you look at the decision, they say something like, listen, most law enforcement now, and you know this if there's defense lawyers in this program. In fact, it's to my bane that almost everything's on video these days. You got to watch the thing in real time. It's just brutal. That's why I send all my videos as a defense lawyer out to be transcribed, because it's just brutal. But the Supreme Court said, listen, nearly all police departments have pretty good video recording stuff now. There's no excuse not to do a video recording of the out-of-court identification. So we're going to be paying close attention if you don't use that video. We're not saying you have to do it. Like child interviews, they've been saying this since '92. We're not saying you have to video record it, but we're a lot happier if you do. And we're going to look very skeptically at out-of-court identifications that are not video recorded. So I would suggest, if there's any prosecutors or law enforcement, you got to record these with the computer, with the video camera. You can't take good copious or verbatim notes. It's a bit of a misnomer to call anything verbatim. Okay, the only thing verbatim is the video or an audio, and they want video. They don't want audio. But now the recording is video. It's not just taking great notes. And it requires the officer to document, and that's okay. You have to have an articulable basis or tell the story why you didn't use video. You just can't go, hey, we were kind of busy that day. Someone else was doing the video. It broke. Well, you got body cams, you got iPhones. Give us a good reason, will you? It requires officers to document their reasons for not recording the identification procedure electronically or preparing a contemporaneous verbatim account of the process. That's Anthony. This is an extension. This is Henderson and where we are now with Henderson, okay? Anthony also modified Henderson and held that defendants are entitled to a pretrial hearing when there's no electronic or contemporaneous written verbatim recording, even without evidence of suggestiveness. And what do I mean by that? Defense lawyers, in order to get in the courtroom on a Wade hearing, you have to show some evidence of suggestiveness. The Supreme Court in Anthony said, listen, if the police do not record anything or are deficient in their recording of the out-of-court identification, then you don't need to show suggestiveness. You get a hearing right away. If the cops did not do a good job of recording the out-of-court ID, then you get your hearing. You don't even have to show suggestiveness or system errors. Pretty cool if you're a defense lawyer. And check it out, defense lawyers. They proposed, and they did this, a change to the model jury code. You get an adverse inference. If it looks like the police didn't have a good reason, by adverse inference, you tell the jury, they didn't record. We encourage recording. The rule is they should record. They didn't record. You can look skeptically at the out-of-court identification because the police did not record and didn't have a good reason. That came out of Anthony. Again, extensions. And to my point that there's a lot of action in this area, January 2024. And as a prosecutor, I don't like this one bit. I don't like it one bit, but I'm not a prosecutor anymore. So as a defense lawyer, I think it's a great idea. You have to video record the pretrial prep of the witness. Oh my God. Oh my God. If you're a prosecutor, this is a bad day. This is a bad, not because anything nefarious was going on, but you know what? There's just a reluctance for anybody to have their practice and procedure scrutinized, and now you have to be extra careful. And it's a bit of an overstatement saying that the trial prep has to be recorded. What Washington says in January 2024 is when you're prepping your witness, prosecutors, and you're discussing the out-of-court ID, you got to turn the video camera on. If you're going to do that, you might as well turn the video camera on for the whole trial prep. I don't know that the court's going to draw a distinction ultimately when the next case comes up. But the court extended the relevant principles in Henderson to trial prep sessions. Witnesses who have made a prior identification should not be shown photos of the defendant during trial prep. Neither new photos for the first time or absent a good reason, the same photos. So when you're prepping your victim who was attacked by a stranger, you can't show her the pictures from 2 years ago or any pictures to prep, to jar their memory, to refresh their recollection. No way, no way, not good, can't do it, no way. This may be extrapolated, and I said it to my dear colleague, Chris Freed, who's also doing defense work now, but I've talked to prosecutors about this. I spent most of my career with children, and there's a lot of concern over children under 10 and the potential for memory error with them as well. And when I was a prosecutor and prepping the child, we would often, if not always, show the video to the child. Well, I don't know if you can do that anymore. That's not a Wade decision. The decisions under Idaho versus Wright and under the cases in New Jersey are not Margaret Kelly Michaels and its progeny. They're not Wade cases, but Margaret Kelly Michaels made the decision of the Supreme Court in that case was based upon the analogous research and law in Wade identifications. Margaret Kelly Michaels is a memory error case. Out-of-court IDs are memory error cases. I think there's a compelling argument to be made that all trial prep, where there's the potential for distorted memory or memory error, need to be recorded. I was talking to my colleague, Laura Sutnick, and I think she said she may have argued that, or she prevailed with that argument. I'm not sure. I don't remember, but I would suggest that it's probably something whose time has come, where prosecutors need to record the trial prep with a child of tender years in a child sexual abuse or even a child physical abuse case. But that remains to be seen. This is just me telling you what I think. What about Brandon Washington? If a party can demonstrate a good reason to show a photo, so prosecutors, you can show the photo, but you must do a written record. Better yet, video record it. If there's a reason, and I don't know what it might be, there may be a compelling reason that you want to show the picture to the person again, okay? Or show them a different picture. Maybe the guy's got a beard now and he didn't have a beard then. I don't know what the right answer would be to showing them a picture, but if there is an answer that's persuadable, then you can do that, says Washington. I mean, the default seems to be you can't do that, but if you have an articulable basis, a really compelling reason why you would show the person you're preparing for trial a picture, well, then do it. Just make sure you record it. Just make sure you record it. Now, if the witness never identified a suspect, let's say you get to court and there's other compelling evidence when you did the out-of-court ID, she goes, I don't know who did it. I looked at the 10 pictures and none of them are there. Could be that guy, could be this one. You don't have an out-of-court ID. What happens then in trial prep? Well, a witness who has not previously identified a suspect, you can bring the investigators back and you can do the identification procedure consistent with Henderson. You can try again, essentially, but you better put it on video. You better put it on video. And if you look at Rule 311, all this stuff is included there. We've reached the end here, but I'll tell you this, the federal courts are not impressed with Henderson. Perry versus New Hampshire rejected it. It's totally focused on police behavior. They could care less about Henderson. And in a case called Garner versus Colorado, the Supreme Court of Colorado, again, said doesn't matter about estimator variables. The only thing that matters is police misconduct. No police misconduct, you don't get a hearing. So the federal courts shut the door 8-1 in 2012. And the state courts that are conservative went along with Perry, and they've decided that it's only police misbehavior that's actionable. So just an example there, Henderson is a leading edge case. It's not something that the federal courts have adopted, and many state courts have rejected it as well, including the Colorado Supreme Court. And I bring up this case because it went to the Supreme Court and cert was denied. And this was a great case for the defense, and the American Psychological Association wrote a compelling amicus brief in the certiorari request, and they lost. It didn't go. Supreme Court rejected it. So this Colorado Supreme Court was the final pronouncement on this issue. So there we are.
Joe, at this time, I'm sorry to interrupt. I have to give everybody the program code.
Let's do it.
Okay. Your program code is MT13. Again, that's MT13. And it's also in the chat.
Karen, you need to hold that up a little bit higher, I think, for everybody.
Is that better?
Yes.
That's Mary Thomas 13,
That's
MT
better.
13.
Thank you.
Well, I want to thank everyone for their attention, and because I had the screen set to presenter view, I didn't see forgot about the code. But I want to thank Jason Dickinson from Montclair State University, one of my favorite people in the whole wide world, and I learned so much from him, and it was great working for him and working with him. One day we're going to write a book with Chris Freed. We'll talk about that this summer, and I look forward to doing that as well. I want to remind you that on November 26th, I'm doing a program on artificial intelligence and the law and the ethics of it. You can get your ethics credits. On December 11th, Warren Sutnick's coming over, and Charles Festa and Hashim Masari and Judge Damiano. We're doing a thing on municipal court and DWI. That's December 11th. The bar will be doing that. December 18th, we're doing a program on diversity and ethics, DEI stuff. You need that as well. That's December 18th, same bat time, same bat place, on the Zoom, just like this, from the comfort of your office. December 18th, Sue Curcio, former chief in the Atlantic County Prosecutor's Office, will be doing that as well.
Some
Anything
of us are biting our tongues, Joey, because you've been using artificial intelligence your entire career.
else? You've been waiting the whole program to do that, Matt, huh?
Pretty much.
Yeah.
I also gave you a shout out in the chat, Joe. I was a young law clerk watching that trial you talked about.
Yes.
Yeah, that's a real left-handed compliment on that one.
A very young law clerk.
Yeah. I was a young lawyer, so that's okay. Not anymore.
Thank you, Joe.
Thank you.
Thanks, Joe.
Good
Thanks.
job, Joe. Good
Bye.
job.
Bye-bye. Chuck, I'll
Thank
talk
Thank
to
you,
you.
Joe
Karen.
and Jason.
I'll see you
Thank
later.
you,
Thank you,
everybody.
Jason.
Bye.
Have a great week. Thank you again.
Yay.
Bye.